Morning. I have the great opportunity to start the session off with really good news. Uh, this past summer, the Supreme Court issued a decision that goes a long way to clarifying and improving our religious liberty, especially as religious organizations, churches, and Christian nonprofits strive to have control over their governance without interference from the government. So some of you may have read in the paper this summer about the court's decision in Our Lady of Guadalupe School, Morrissey Beru, combined with St. James School versus Beale. Really two different Catholic schools and two teachers involved. We had two elementary teachers in the case. They were Catholic schools in the Archdiocese of Los Angeles. I've had a chance to talk to the general counsel for the Archdiocese and a little bit about the case, but for both of these individuals, they were regular elementary school teachers in parochial schools. As part of their duties, they taught religious instruction on a daily basis. They prepared students for Mass, for communion, for confession. They also prayed with their students and took them to Mass weekly. In both cases, the teachers had employment agreements with the Catholic diocese that required them to model and promote the Catholic faith, to promote Catholic faith and morals, to participate in the school's liturgical activities as requested, and the agreements provided that the teachers could be terminated if they failed to uphold their responsibilities or conducted themselves in a way that cast discredit upon either the school or the Roman Catholic Church. They also had school manuals that described the role of the teachers, described their responsibilities in terms of Catholic faith and instruction. So it was very clear what they were to do. In 2014, the Our Lady of Guadalupe School asked Morrissey Beru to move to a part-time position. And at the end of that school year, they declined to renew her contract. She claimed that that was due to her age, and the school contended that she was terminated based on her poor performance. Let me just digress for a second and note that we don't really have any trial record about why she was terminated. There weren't depositions and discovery and all of the typical trial proceedings, because all of this was decided based on initial motions to dismiss based on claims that both schools made that the teachers could not pursue their claims based on a doctrine that is called the ministerial exception, and we'll talk about that in a minute. Kristen Beale was a teacher at St. James School, and like Morrissey Beru, she was an elementary school teacher. She taught for a year and a half. Halfway through her second year of teaching, she asked for a leave of absence to pursue treatment for her breast cancer. At the end of that school year, her school also declined to renew her contract. She claimed that she had been terminated because of her medical condition in violation of the Americans with Disabilities Act. But the school, like Our Lady of Guadalupe contended that the non-renewal was based on poor performance. So those are the basic facts of the case. We don't really know much more than the agreement or the arrangement by which these teachers were employed, the standards they were expected to abide by, and the fact that they were terminated in circumstances that in ordinary case, if it was not a religious organization, would certainly have entitled them to proceed to trial and go through very expensive litigation over discrimination cases. In the one case, it would be an age discrimination claim under the Age Discrimination Act. The other would be a disability claim with the Americans with Disabilities Act. That brings us to an understanding of the law that was applied to the case and why the district court dismissed the cases initially using a doctrine that is known as a ministerial exception. We'll probably need to think of a new name for the doctrine because, as you'll see, one doesn't have to be a minister for this doctrine to apply. So it's really a doctrine that protects the religious organization's ability to select those that carry out their religious mission. The doctrine was created by the courts, really grounded in the First Amendment, to protect the autonomy of religious institutions, both to govern themselves internally, to declare their own faith and doctrine, and any actions that were essential to pursuing the institution's central function. One of I should say the first time that the Supreme Court addressed this issue was in 2012 in a case called Hosanna Tabor Lutheran School. In that case, that also dealt with a teacher. Cheryl Parrish was a kindergarten and fourth grade teacher at Hosanna Tabor School. As part of her duty, she led students in prayer, taught a religion class several days a week. After 5 years at the school, she took medical leave, and at the end of her contract year, the school declined to renew her contract, similar to the situation that we had with Kristen Beal in St. James School. She pursued a claim for under the Americans with Disabilities Act, and the Supreme Court in that case unanimously agreed that her claim should be dismissed pursuant to the ministerial exception, regardless of the merits of her argument that she had been discriminated against. The court declined in Hosanna Tabor to adopt a rigid formula for deciding when a employee qualifies as a minister. In that case, the court focused on 4 different circumstances. Parrish was given a title of minister. She had advanced religious training. She was commissioned, and her job duties required her to carry out the church's mission. Since that case, the ministerial exception has been applied in over 200 cases. So that brings us to the court's decision in Our Lady of Guadalupe. The court held that the circumstances in the Hosanna Tabor case were not necessary in order for the ministerial exception to apply. They said at bottom, what matters is what an employee does. Are they carrying out the religious mission of the organization? Do they deliver the message of the church or the religious nonprofit? They focused on the fact that in that case, those teachers were educating young people in their faith, inculcating their teachings, and training them to live their faith. So that brings us really to how do we apply this case? In all of these cases, you see that they were teachers. How far does this doctrine expand? Would the Supreme Court hold that someone who did not have the title of minister, but who was in charge of the outreach ministries of a church be carrying out the religious mission of the church? How far would you take the exception? Let me mention that as part of the court's decision, they basically acknowledge that judges don't know what the religious mission is of every church. So these takeaways are based on the fact that you can really help yourselves frame the facts, help courts connect the dots, so that when a case comes up that fits in under this doctrine, you can avoid or at least eliminate most of the litigation or the divisive activity that takes place in the employment claim. First of all, the question is, how broadly have you defined your religious mission? Is it more than proclaiming the gospel or a particular, Christian education? Where do you draw the line? So you need to figure out how broadly you should draw the mission. Secondly, who are the employees that are critical in carrying out that mission? What are their duties? And you should define those in job descriptions, in church, in personnel manuals, in employee handbooks, in policies, wherever you can. Try to show how that individual, their work is defined and it fits with the mission of the church. Require them to acknowledge and agree in writing that they understand and will perform those duties. And then at least annually assess that they are actually performing those duties as specified in the job description. So with that, I'll see if there are any questions.